Welcome to Section 2 of the Sexual Harassment Training. Thank you for joining us. My name is Cheryl Sharp. I am a commission attorney and the Deputy Director of CHRO. I am joined by my esteemed colleague.
I'm Michelle Dumas-Kuehler. Thank you for that. I am an attorney at the Commission on Human Rights, and we'll begin Section 2 with the slide entitled Sexual Harassment is Illegal Under Federal Law. We follow the federal law, which is Title VII. It was passed in 1964 as part of the civil rights statutes that were passed during the 60s. It originally covered race, color, sex, national origin, and religion. The EEOC has very good interpretations of what sexual discrimination means, and you should consult their website in order to get information about coverage of the federal law and best practices. The federal law, as does the state law, applies to public employees. It applies to labor organizations and employment agencies, and it also applies to private employers who have 15 or more employees.
Connecticut law also prohibits discrimination based on sex and prohibits sexual harassment. Connecticut General Statute Section 46A 60B8 prohibits sex-based employment discrimination. It specifically forbids an employer and those acting on behalf of an employer from harassing employees at work based on their sex or their gender identity or expression. There's a definition for gender identity and expression, and it is found in 46A 5124 for those who are interested in statutes. It specifically says a person's gender identity, related identity, appearance, or behavior, whether or not that gender-related identity, appearance, or behavior is different from that traditionally associated with that person's physiology or assigned sex at birth.
There were many updates to the Connecticut law that will become effective October 1st, 2019, and that's the reason you're watching and listening to this training right now. But one of the updates concerns the CHRO sexual harassment poster. That poster is found at our website, www.ct.gov/CHRO. It is now mandatory that employers post the CHRO poster. The employer also must distribute copies of the sexual harassment policy to all existing employees as of October 1st of 2019. For new employees after that date, the sexual harassment policy must be distributed to those new employees within 3 months. Distribution can include email, posting on an intranet site, by text message, or giving the actual policy in writing. While the law requires that to be done October 1st of 2019, it is a best practice that employers routinely distribute the sexual harassment policy. It will show the employer's intent and desire to make sure that the policy is available and is alive within the organization. That said, it is important that that policy be distributed as often as possible to show the employer's dedication to following the terms of the policy.
Also, Michelle, employers with 3 or more employees in their employ must provide 2 hours of sexual harassment training to all employees before October 1, 2020, and thereafter within 6 months of hire. The training has to be updated every 10 years, and this is an important fact for employers to realize and understand.
A new feature to the statute under 46A-97 allows employees of the CHRO to go out to businesses and inspect whether they are keeping posters and records of the distribution of their sexual harassment policy. If there are no posters posted or records kept of the actual distribution of the policy, that employer can be fined a fine up to $750 for noncompliance with not only the posting requirements, but also the training requirements under the statute.
And the state law requires employers to eliminate harassment and take immediate corrective action. However, the employer should be aware that you cannot modify the work conditions of a employee complaining of the harassment without written consent from that employee. There are limited exceptions to this rule.
Another new feature to the statute is that human rights referees, after the conclusion of a public hearing, can award damages that are necessary to eliminate discriminatory practices and make a complainant whole. What might be a more common term to employers and employees is what we call emotional distress damages. Those damages, which are usually beyond front pay, back pay, and other types of compensatory damages, are what will now be figured into damage awards in order to make the complainant whole after the discrimination has occurred and a referee has determined that a discriminatory practice has occurred.
And at this point, you may be asking yourself, well, what types of damages are actually available to victims of illegal discrimination that is sexual harassment? Uh, we have back pay, front pay, attorney's fees, costs. There could be a cease and desist order issued by a human rights referee. There are prejudgment and post-judgment interest, emotional distress damages, as my colleague here just spoke of, punitive damages, which you can only get in court, and a civil penalty if the commission elects to take the case to court as opposed to having it heard in front of a human rights referee. So there is a great cost to discrimination. There's a great cost to sexual harassment, and both the employer and the employee should be aware of these costs.
This presentation has been focusing on sexual harassment in the workplace, but it's important that everyone knows that sexual harassment is illegal in other areas of one's life, including housing and in places of public accommodation. Under 46A64C, which is the statute that protects everybody from being discriminated against in housing, it is illegal for a tenant to be discriminated against through sexual harassment. And that discrimination can occur not only from the employees of the housing provider, such as a leasing agent, a maintenance person, somebody who works for the housing provider, but it also is illegal for a tenant to sexually harass another tenant in their housing, and something that the housing provider needs to be aware of in order to make sure that they're not engaged in discriminating against the tenant. The other place that it is illegal to sexually harass somebody beyond work and housing is the public accommodation. Under 46A-64, which is the state's public accommodation statute, it is illegal to not only discriminate in all of the protected classes, but to sexually harass somebody. Places of public accommodation include retail establishments such as the mall or a grocery store or a big box store, any of those types of places, a doctor's office, a place where you would get your car fixed, any public services that you would receive. The government, if you come to any state building, any municipal building, you are protected under the law from being sexually harassed. The police department, and many other places.
Such as schools and where you go to get your hair done, your nails done, those are all places of public accommodation, and the law protects you from being sexually harassed in those different places. So our law in the state of Connecticut is very vast and robust as it relates to prohibiting sexual harassment.
Please pause the video and take quiz number 2 in the material section.
Welcome back, everyone. Thank you for taking the quiz. Let's explore the answers to this question. The water delivery man always makes comments about the receptionist's clothes and body. He's not a company employee. If she complains to her boss, what can be done, Michelle? Anything?
I feel B is the right answer to that. The company can complain to the delivery person's employer and ask them to remedy it.
How many of you selected B? If you did, you got the right answer.
Question number 2. My coworker posted a picture of me in my swimsuit from the company picnic on his Facebook page without my consent. Everyone at work is teasing me. Is this sexual harassment?
Yes, I think it is, Michelle. I think that is sexual harassment.
And I would agree with you, Cheryl. It is sexual harassment. This is a very complicated area in terms of what spills over into work from the things that we do in our private life. And while this was a company picnic, and I'm assuming the person knew that there was a potential that their picture would be taken in a bathing suit, they have every right to engage in the bathing suit being worn and them going in the pool without fear that it's going to spill over into work, which it clearly did. Teasing somebody for activities that happened outside of work, in work, is sexual harassment. And why? Because it interrupts the work environment with teasing based on one's appearance, which is of a sexual nature.
Question number 3. Sexual harassment is illegal under, what did you guys select? We talked about federal law and state law and the prohibition under both. So the correct answer is C. Sexual harassment is illegal under state law and federal law. The Commission on Human Rights and Opportunities enforces the state law. And there is a state statute, 46A 58, that makes it illegal when you violate federal law, that you have actually violated state law as well.
Question number 4. If an employer does not follow the posting or training requirements, what happens? The answer is C. The CHRO can impose a $750 fine for violations of this section of the statute.